so that we could jump right into our conversation for today. So again, welcome everyone. My name is William Moore with OJJDP NTTAC. Thank you all for joining today's web event. Let me click the next slide here. Expunging juvenile records, misconceptions, collateral, consequences, and emerging practices. Before we start today's presentation, I wanted to take a few moments to go over a few housekeeping items to keep in mind. Please note that we are recording today's web event, and it will be published on OJJDP's multimedia page. Please note that on OJJDP's multimedia page, you are able to view archived web events. If you would like to access any supporting materials related to those web events, please be sure to reach out to the OJJDP NTTAC Help Desk to get access to those items. If you're having trouble downloading the event materials, please remember, as I mentioned earlier, a Google Drive link has been placed inside of the chat window. Just simply click on that file, that URL, or copy and paste it into a web browser, and you will get access to the webinar materials there. If you're still having issues accessing the materials through that Google Drive or through that file transfer option that I provided there, then just contact the OJJDP NTTAC Help Desk and we'll be able to get you those materials or that PDF. For optimal audio, please dial out through the WebEx system to your phone line. When you're connected, you'll see a phone icon appear next to your name in the participant panel. That's how you'll know you are connected. Please note that all webinar participants have come in through mute. So if you are a participant and a panelist, just note that you are indeed muted for today's web event. Only the panelists will be off mute. Only the panelists will also be on video. So if you're seeing a video of yourself, that's okay. Just note that only the panelists will be seen here. All right, and if you're experiencing any technical difficulties during the web event, please be sure to send me, the host, a direct message, and I'll be more than happy to assist you. Now, we will do our best to take questions during today's web event. However, we received over 100 pre-submitted questions during the registration process. So for those who would like to send your question, please do so. We will try to do our best to get to them during the Q&A portion, but please note we did get a huge interest in this particular web event, and Andrea will do her best to try to get to as many questions as possible during the Q&A. But if you don't get your question answered, then please note that we are recording your question. To send in your question, what we want you to do is go to the chat window. You would type your question. However, before you hit send, make sure in the to file as displayed on this slide, you have either everyone or all panelists selected. Again, before you send in your question, make sure that you have either everyone or all panelists selected, and then you hit send and we will retrieve your question. If you have any questions, again, related to the technology for today's web event, just simply message me, the host, directly, and I can help you with any issues you may have with the technology. Let's see, our poll question is closing here. So thank you all to those who participated in that poll. All right. All right, really quickly, help us count. Let's do a practice. If you are viewing by yourself, there's no need to type anything at this time. However, if you're viewing in a group, meaning it's yourself and additional people, please go to the chat window and type in the total number of additional people in the room with you today, not including yourself. So if it's you and your program manager or you and another individual, you would put in +1. Or +2 or +3. So type in the total number of additional people in the room with you today, not including yourself. And again, please send that to all panelists or everyone, and we will be able to record attendance. Following today's event, you will receive an automated email from WebEx with your certificate. Please be sure to add messenger@webex.com ojjdp.com to make sure in your safe sender list to make sure that you receive your certificate of attendance. Here's an agenda for today. Before we continue on, thanks for joining, Andrew. Really quickly, can I get a mic check 1, 2, just to make sure that your audio is coming in okay?
Can you hear me okay?
There you go.
Hopefully
Perfect.
I'm coming in, and sorry for scaring everyone.
No worries, no worries. We're glad you're safe and made it on okay. All right, thank you, Andrew. I appreciate that. All right. So that being said, I'm going to go ahead and turn it over to Andrea. Andrea, you are now the presenter, so you can now move along the slides there with no problem, and she will welcome everyone and provide more information for today's webinar. Andrea, take it away.
All right, thank you so much, William. Thanks for always in tax assistance in doing our web events and other events for OJJDP. So welcome, everyone. We're so thrilled at the momentous response that we've gotten for today's webinar and web event. This is really sort of just going to be, even though we're going to be presenting information, this is really going to sort of be a conversation, and I hope the beginning of a conversation around this very important and timely topic. Again, I'm Andrea Coleman, and I'm a Senior Policy Advisor at OJJDP. I've been at OJJDP for nearly 15 years and previously served as the agency's Disproportionate Minority Contact Coordinator. And so I've done lots of stuff. Before I came to OJJDP, I was a state DMC coordinator. So a lot of you all, I see names and folks and friends that I recognize from the field. So good to see you on. So again, today we're going to go through this information. And from my perspective in moderating this webinar today, I'm going to talk a little bit about the bulletin that was sent in the link to the webinar registration and really give a 20,000-foot high view of the bulletin and why OJJDP sort of decided to engage in this work and delve a little bit more deeply, I think, than we've done probably in more than a decade. So with that, we will go ahead and get started. So we have a couple co-presenters with us today. We have Andrew Keats, who's at the Juvenile Law Center in Philadelphia, and he's going to talk about the Law Center's scorecard, which was really integral in helping me write the bulletin. And so it has tons of information on state juvenile expungement and sealing and confidentiality laws and where they sort of rate on the spectrum. And so when I was going through some of the questions that were submitted before, a lot of folks sort of asked that question, sort of, you know, where is my state? You know, where do we sort of rank? And what's the difference between expunging, sealing, and confidentiality records, which I will get into here in a sec. We also have Kaylee Richards with us, who is the Juvenile Justice Specialist, or we like to say in our world, the JJ Specialist, for the great state of Utah. And Utah Commission on Criminal and Juvenile Justice actually receives Title II formula grant funds from OJJDP. They are the designated state agency to carry out the programmatic requirements of Title II and also what we commonly call the 4 core requirements: the institutionalization of status offenders, removing kids out of jails and lockups, sight and sound separation, and racial and ethnic disparities, also still known as disproportionate minority contact, or DMC. We also have Maria Pena with us, who is an appellate attorney with the Utah Juvenile Defender Attorneys. And Marina's going to talk a little bit about the work that they do with expungement clinics. And they've received support from Kaylee's shop. And so we wanted to make sure that we had not just me and OJJDP presenting this information, but we wanted to have voices from the field, because we can only do what we do because of the work that you all do out there on the front lines in the field. And there are days that I really do miss that work, sort of being here in DC. There are lots of days that I miss being on the ground. So we couldn't do what we do without you. So our vision at OJJDP. Our vision is that we think of a nation where our children are free from crime and violence. If they do come into contact with the juvenile justice system, the contact should be both just, and we used to say rare, and beneficial to them. So OJJDP works daily to try to strive to make our vision become more a reality. Our mission: we provide national leadership, coordination, and resources to prevent and respond to juvenile delinquency and victimization. We support these efforts of states, tribes, and communities to develop and implement effective and equitable juvenile justice systems that enhance public safety, ensure youth are held appropriately accountable to both crime victims and their communities, and we most and foremost want to empower the kids that we come into contact with to live productive lives. And I think that's one of the things that sort of really at OJJDP internally is that we really want to empower youth and young people, and we also strive to do that daily. So the session objectives for today. So what are we sort of going to talk about? We're going to define juvenile records expungement, sealing, and confidentiality, and how, the practices vary based on state laws. There's a lot of sort of confusion around what expungement means statutorily, sealing, confidentiality, what do we call it? Sometimes it's expungement by the law, but sometimes it's sealing in practice, and sort of all the way around. So we're going to talk about that again, getting that 20,000-foot high view. We're going to just review a few collateral consequences of young people that have juvenile records. And I talked about with our mission and vision, making sure that we empower young people. It's really difficult for young people to be empowered if they have juvenile records and they're attached to them and trying to get jobs and housing and employment and education and all those kinds of things. We'll talk a little bit about that. As I said in my sort of early remarks, we're going to look at the juvenile records expungement via the Juvenile Law Center scorecard, which Andrew's going to talk about. And then again, discuss emerging state and local records expungement practices in the great state of Utah. So terms to know. So this was, and as I was writing this, and, I admittedly, disclaimer for myself, I knew some things about juvenile records and sort of the confusion that existed around it, but not as much as I should have known. So when I was doing this research and reading and looking at the Juvenile Law Center's documents and all the literature out there, it became abundantly clear this is the reason why folks are so confused, and particularly young people, the people who we're trying to serve the most. So let's start with expungement. Expungement is the process of destroying and eliminating juvenile records. The goal is to make it as though the records never existed. The process is not always comprehensive in practice. And so several of the questions that we got prior to the webinar today was, okay, well, yeah, what does expungement mean? If the records can be expunged from court, can law enforcement still access them? And in a lot of states, the answer is yes. So even if they're expunged from court, or a court record doesn't show up, or a detention record doesn't show up, police can still access those records depending on where you live and what state you live. So that's the reason why we added there that this is not always it's not always comprehensive in practice. So the next term, sealing. Sealing makes juvenile records unavailable to the public, but allows some agencies and individuals to access those records, right? So those, quote, some agencies could be schools. One of the things that I saw in the research is that even though when kids had, been in facilities and they come back to school, that schools in certain states can't access those juvenile records, right? The public may not be able to see them, but schools and other social service agencies may be able to access those. Confidentiality laws. They require that states make juvenile records confidential, allowing, again, access to schools, crime victims, the media, and the public in specific instances. And in most of these instances, when we're focusing on the media and the public, it's usually more serious offenses, more than just, the sort of run-of-the-mill delinquency sort of offenses. And so usually the media will try to access juvenile records if there is some sort of, serious offense. And, we all watch our evening news, and if you ask, those of us who do this work, if you ask, your neighbor or family members or people in your life, if you think juvenile crime is worse now than it's ever been, most of us will get, oh, of course it is. Yes, it's way worse than it was when I was a kid or young person. And it's really not. It's just the way, of course, that it's reported, right? And so when you're watching your evening news and the media has access, if a young person has been alleged to have committed a very serious crime, sometimes they have accessed those records. And if that's what you see, on your 6 o'clock news every evening, then that's what you tend to think juvenile delinquency and crime is. And it really isn't. Those crimes, those can be serious, are really statistically the anomaly. So let's talk a little bit about sort of collateral consequences. So what happens to a young person that has a juvenile record, right? So if a young person gets arrested or adjudicated, which is the same as the equivalent of going through sort of the adult process, and if there's an adjudication of delinquent, that means that's equivalent to being found guilty in the adult system, okay? So big word, adjudication. So these consequences are in addition to any fines or sentences handed down by juvenile courts. According to the National Institute of Justice, which is OJJDP's sister office at the United States Department of Justice, collateral consequences are a host of sanctions and disqualifications that can place an unanticipated burden on individuals trying to re-enter society and lead lives as productive citizens, right? So again, not only do you have the record itself, you could have fines or sentences, of course, attached to those records. So what are the significant consequences? Difficulties include, but are not limited to, again, accessing educational services such as student loans, obtaining employment, finding and maintaining housing, and entering and serving in the military. So I want to focus a little bit on the housing and entering the military. So let's look at housing. So what happens in housing is that landlords, for the most part, should not, particularly in public housing, have access to kids' juvenile records, but what they do is there are workarounds to that. They have information and sharing agreements with law enforcement, particularly if there might be young people in public housing or income-based housing that are familiar to police, and so they sort of have these either formal information sharing agreements or informal information sharing agreements where the police will report to these landlords who has a juvenile record or who has known to law enforcement. And so that can result in families being evicted from public housing or income-based housing. And one of the pieces of literature that I reviewed, the Illinois Juvenile Justice Commission did this really great study. And one of the local prosecutors in Illinois said, if we keep doing this, we're going to create a class of people where they will have nowhere to live based on young people having juvenile records. So then let's talk about entering and serving in the military. So if you want to go to the military, you're a young person, there is what's called a moral waiver that you can obtain from the military, but it only covers certain offenses. So any young person that's accused of a sexual offense that results in a felony, then the military can decide not to grant that moral waiver. And so that's, prickly, right? Because again, if this is the path you want to take and serving our country, you may not be able to do that if the military does not grant that moral waiver. So these are just the major collateral consequences of having juvenile records. So with that, I will turn it over to my colleague, Andrew Keith, at the Juvenile Law Center in Philadelphia to sort of talk about the scorecard that we talked about in the session objectives. So with that, Andrew, take it away.
Thank you, Andrea. Again, I'm Andrew Keats. I'm a staff attorney with Juvenile Law Center. And the reason I'm here today is because one of my projects for the past couple of years has been our Second Chances project. Our Second Chances project evolved actually over the years out of two efforts that began maybe 15 years ago for us to engage and work with youth with system involvement and uplift their voices and listen to their actual needs. We started Juveniles for Justice, youth advocacy group with juvenile justice system involvement. We started Youth Fostering Change for youth who have foster care system involvement. And what we started to hear, just as Andrea mentioned, there was a widespread belief that what happens when you're in the juvenile court and your juvenile record doesn't ever come out, and you start off 18 with a clean slate. But it took us really listening to our youth to start seeing this is a common problem. Youth are coming out of the system and they're running into all the problems Andrea is talking about. And I want to read off some of the statistics on that in a second, but listening to them, we started to look into, we focused on it locally in Philadelphia where our headquarters is, and then undertook a project to look at it across the country. That led in 2014 to the report posted up on the left, Failed Policies and Forfeited Futures, which was our scorecard analyzing all 50 states' juvenile records laws, their laws on confidentiality, sealing, and expungement. And I'll get into sort of how the scoring works and some of those results. But in connection with that, our results showed states are really underperforming in setting up a framework and legal system to protect juvenile records. And in connection with that, a few years later, we produced the report on your right, Future Interrupted, on the collateral consequences of juvenile records that really mirrors a lot of what Andrea was describing and what appears in the bulletin, which I thought was an excellent piece of work and really uplifts a lot of the issues we see with juvenile records today. The statistics really show you that public access to juvenile records and really as much access, even limited access to schools, other governmental agencies beyond just the court and maybe law enforcement. In our internet age where sophisticated search engines can pull up anything that's on a public database, these records get out. And so, for instance, in housing, youth between the ages of 14 to 21 who've experienced homelessness, 44% have been in juvenile detention center, jail, or prison. Nearly 78% had at least one prior interaction with the police, and nearly 62% had been arrested. And this often happens, homelessness from youth with records, especially with public housing, are often foreclosed from those opportunities. And also, if a family member has a record, the whole family can have trouble accessing public housing specifically, and it sets youth and their families back tremendously, and it's really a public safety issue as much as it's a juvenile rights issue. In higher education, while there's been efforts made for ban the box, and especially on standard applications, it's still the questions on arrests and even juvenile records are asked, especially in private universities, and just the asking of these questions, whether or not a institution considers the merits or evaluates it in connection, just the question itself, 62.5% of applicants were discouraged from even completing their application when there's a disclosure requirement. 33% of colleges and universities collect records, who do collect records, have viewed any admissions or records negatively in the evaluation of the student, and 20% of applicants reported their applications were denied when they reported system involvement and records. In employment, 90% of employers run background checks. 50% of employers say they're unlikely to call someone back. 40% say they will definitely or probably not hire an applicant with a criminal record for a job. And 11% of employers have reported that even minor criminal infractions would prevent someone from getting a job. For individuals between ages 18 and 25, 50% of them were unemployed and had previous juvenile justice experience, reported at least one new conviction in the adult system, compared to 28% of individuals who were able to work full and part-time. So by excluding people from job markets, housing markets, education, we're just setting them up for recidivism and an inability to ever become productive citizens. And that really takes us to, why the myth of, the privacy and confidentiality of juvenile system involvement is so different from the reality. Beginning about over 100 years ago when the juvenile system was created, it was geared towards and is supposed to work towards rehabilitation. And as part of rehabilitation, the system was created to prevent kids from getting the stigma of being branded a criminal. That's part of the need to rehabilitate, and the goal of rehabilitation was understood that records and a presumption of criminality would be damaging to the prospect of becoming productive citizens and becoming able to re-enter society. Even in 1967 in Inri Galt, when juveniles in the juvenile justice system were recognized for having constitutional rights, it was widely understood and believed that the policy of the juvenile law was to hide youthful errors from the full gaze of the public and bury them in the graveyard of the forgotten past. That was language in the decision. Even in 1979, in a concurring opinion, former Chief Justice Rehnquist noted it was the hallmark of our juvenile justice system that virtually from its inception at the end, it's been conducted outside the public's view, and the youths brought before juvenile courts are shielded from publicity. But clearly something's changed, and there's a number of factors that have weighed into that. First, we went through the 80s and 90s in a period of, in addition to mass incarceration, policies like broken windows, stop and frisk, funneled more and more kids into the justice system. Myths like the super predator myths led folks to view youth as more dangerous. And so there's less of an interest in keeping their records confidential because public safety required greater vigilance against youth. Following that, we had the war on terror, which led to a sort of outgrowth of transparency between interagency collaboration, sharing information. So information available to law enforcement became available to the FBI and often shared across multiple government agencies. And then in connection with that, you had the internet age, as I've mentioned, where sophisticated search tools can be used by employers, by universities to find any possible public information on any individual. But then we also had, during that same period, a legal movement to really recognize the brain science that shows that youth are different. Their acts are not inherently criminal. They're normal youthful acts. Their brains aren't fully developed. They don't weigh risks as well. They don't plan for the future as well. They're easily influenced by peers and manipulated. But most importantly, they're capable of rehabilitation, and the actions and behaviors they exhibit as youth are not do not demarcate exactly who they are as adults. They aren't inherently criminal if they exhibit some delinquent behavior from youth. And that, as the Supreme Court recognized those fundamental differences, that youth need to be treated different than adults, we've seen in the ensuing years a real drop in incarceration of youth and other reforms to try to limit the criminalization of youth and reduce the incarceral impact that system involvement could have on youth. But even with our abilities to reduce incarceration, reduce youth system involvement, the records continue. The records follow youth for the rest of their lives, potentially, if greater steps aren't made by states to protect their confidentiality and enable easy expungement. So first in 2014, when we reviewed the state's laws, we put together a framework to weigh and ask questions about the efficacy of state laws around protecting juvenile records. And we developed a set of core principles that was developed in 2014. And then 2020, this year again, we reviewed those states' laws once again and rescored the states a second time to see movement and improvement or any change that's happened in the ensuing years. And in that process, we further developed our core principles, added some additional questions and areas we wanted to look at among state laws to really weigh the efficacy of their juvenile records laws. Here is the core principles that youth law enforcement and court records are not widely available and never available online is an obvious and easy statement. Court records have often been the subject of confidentiality and expungement laws, but law enforcement records are often just as available as juvenile court records can be, and protections afforded to juvenile records need to extend to the records held by law enforcement from arrest all the way through prosecution and beyond in order to ensure confidentiality. The difference, as Andrea was saying, was that then there's sealed records, which in reality, I look at confidentiality and sealing as very similar processes. Confidentiality requires they be separated from adult records, removed from public view, limited in who can access them, and needs-based access only, with limited exceptions. Expungement means that records are destroyed physically, where they're in physical form, and deleted electronically. And also, it requires that youth be able to answer questions on any of these employment university forms of what it means, whether they have a record or not. They have to be able to answer in the negative. They have to be notified of the ability to have records sealed and or expunged, and the criteria that they need and timing when to file. Records for every offense should be eligible for expungement. There shouldn't be exceptions for certain offenses versus others. Really, all juvenile records should be subject to expungement. The expungement should happen at the time a case is closed, not years later. There shouldn't be any costs or fees. Often, even small costs and fees associated with seeking expungement will foreclose that opportunity to vast majority of youth in the system. Really, sealing and expungement should be automatic. The burden shouldn't be on youth to do anything to effectuate their sealing and expungement of records. If it's not automatic, though, the process has to be easy and youth-friendly, simple, direct, and should not require an attorney to do so. Sanctions must be imposed on individuals and agencies that are unlawfully sharing or accessing confidential information or not complying with expungement orders. Juvenile delinquency adjudications have to be treated differently than criminal convictions. And the public just should not be able to have access to courtrooms during juvenile proceedings at all. A lot of states, this is still, juvenile courtrooms are open to the public. So as I mentioned, we looked first in 2014, and that's the national scores are on your left. And 5 years later, not much has changed. Some of those changes are due to the change in our scoring a little bit, but there's been very little movement. Most of the states fall in the 40 to 60% compliance with our core principles. None had got an A, but some states are doing it better, and certainly some states have a lot of work to do. And actually, for a moment, I'll walk folks through the scorecard and the tool we developed. If William, you just want to switch me over, and I'll pull it up on my screen. You'll just bear with me, everyone.
All right, doing a quick unshare of the document here, Andrew, and then let's see. And now you should be able to share your screen and the website there.
All right. Oh, I see it, but I can't. I don't appear able to use the share function. Am I missing something?
My apologies, Andrew. It switched over to the wrong Andrew Keats there. I think you were in there twice. Sorry about that. But there we go. Now you should be able to share now.
All right, let's see. All right, hopefully everyone sees the same map that appeared on the right side of the former screen. Am I doing this right, William?
Yep, you're good to go. Everyone can see the website here.
Great, sorry about that. Brief technical difficulty. So this is the 2020 scorecard where we rescored all the states. You can see the website. And William, if you could post that in the chat, I'd really appreciate it, as I got my hands full. But this is the total scores, and we break it down state by state, but you could also see rankings of states. If you look at confidentiality, you can see across the country, still similar to the total and expungement. Confidentiality laws are generally, most states have them, are a little better than the expungement laws. I'll pull up one state because this is a way we can look at how the scoring works. We break it down for all those issues we covered in the core principles, and if you go to each issue, whether they have hearings, open hearings, convictions versus adjudications, differences whether law enforcement records are confidential, all the exceptions. So if we look at each one, you can see a ranking of states. This is whether law enforcement records are confidential. And like I said, in most states they are not. They're much more widely available and or not protected through confidentiality and sealing and expungement. Court records. I don't know if that changed the list. Exceptions to confidentiality of court records. Some states are really good where there are no exceptions and all court records are kept as confidential, but most states there are exceptions. Whether records are made available to the public. I think it's about, most states are good. Some really need to make a lot of improvement, but everyone, for your state, we really encourage everyone to use this tool, see how your state is doing, see where gaps exist, work with, organizations in your state, lawmakers, to advocate for the types of policies that we identify as ideal policies. And then on this tool, we really advocate for automatic expungement of juvenile records. And as my colleagues from Utah are going to show, even with the incredible efforts they're making, the ability to reach enough youth to get their records expunged without turning it to automatic is really a heavy lift. I actually saw a Council for State Governments report recently where 7% of youth who have records eligible for expungement actually get them expunged within 5 years of the end of their sentence or they turn 18. So without automatic expungement, defenders who are already strapped for resources have a lot of work to do. But my colleagues from Utah have done yeoman's work in trying to move the ball there, and I'm going to turn it over to them to, after William takes us off my computer screen and gets us back in the presentation, I'll pass it over. And again, I really appreciate everyone taking the time to stick with us on this topic today. Really important issue, and even if we do well with minimizing arrests and really lowering detention levels, if we don't address records, the punishments for those who've gone through the system can last a lifetime. So I appreciate it.
All right, I am going to click through quickly, get to where I want to be here. Whoops. There we go. All right. Whoops, one more. That's what I want. All right. Hi, everyone. My name is Kaylee Richards, and as was mentioned earlier, I am the Juvenile Justice Specialist, which is staff support for the Utah Board of Juvenile Justice, which serves as the state advisory group for federal juvenile justice and delinquency prevention acts work and Title II funding through the Office of Juvenile Justice and Delinquency Prevention. So the Utah Juvenile Record Expungement Program, which I'm just going to call the program from now on, is a joint effort between UBJJ, the Utah Juvenile Defender Attorney's Office, the Utah Juvenile Court, the Utah Division of Juvenile Justice Services, and other stakeholders. The program started in 2018 by providing one-stop shop clinics throughout the state to adults and, in some situations, folks who are still juveniles interested in expunging their juvenile court records. We were hosting clinics quarterly in a different region of the state each time, but in March 2020, due to COVID restrictions, clinics were postponed indefinitely. However, once the clinics were postponed, the need for expungement still continued, and the program received multiple inquiries from individuals all over the state asking if and when the clinics would be reinstated. So in response, the program adjusted and began providing expungement services on a call-in basis, where individuals seeking an expungement through the call-in option complete the necessary steps via correspondence with legal personnel at the Utah Juvenile Defender Attorney's Office. While this call-in process is not as quick as the one-stop shop clinic model, it has been a successful alternative. And as things begin to open up and we're able to do clinics again, we are hoping to do clinics and the call-in services as needed together. In Utah, costs for each eligible expungement case include court filing fees, fingerprints or background check fees, and certified mail costs. And the cost of an expungement case ranges from somewhere from $50 to $200, and that depends on whether or not the court filing fee is reduced or waived based on the income status of the client. So expungement services are offered at no cost to the participants, and the program is supported by pro bono legal services and a mix of funding sources, including Title II funding. The 2018 reauthorization of the JJDPA allows Title II funding to be allocated towards expungement services, but that same federal statute caps the eligible amount of funding at 2% of the overall annual funds, which in Utah is about $10,000 right now, depending on the funding year, between $10,000 and $12,000. As Utah's expungement program continues to grow, it has become clear that more funding is necessary, and the program would like to fund maybe a coordinator or an attorney that can dedicate time solely to this effort. That isn't something that we have at the moment. We'd also like to be able to cover costs for more expungement cases in general. So we're working on seeking alternative funding sources to supplement that Title II funding, and we want to have more conversations regarding that 2% cap on the expungement services per this area. So I think that was talked about earlier, some of the funding barriers to these sorts of services to help folks. So we are very interested in having conversations and learning more about other alternate funding sources. So with that little plug and bug in your ear, I am going to turn the time over to Marina Pena from the Utah Juvenile Defender Attorney's Office, who is going to talk about, she's going to provide more detail on the clinics themselves, those call-in services, and the populations served. So, there you go.
Thank you, Kaylee. Thank you. I'm Marina Pena with Utah Juvenile Defender Attorneys. I am primarily an appellate attorney in the office, but I have kind of taken over the expungement clinic under my duties. So I've been the lead person in my office for the expungements. So before I get into the expungement clinics and really go into detail about what that actually looks like, I did want to discuss one of the issues that we face through the expungement clinic process. So, and that's really how difficult it is to be able to answer and advise clients about what an expungement actually means. In Utah, the Utah Juvenile Expungement Act provides that once an individual is granted an expungement, the petitioner's case is considered to have never occurred. And therefore, a petitioner may reply to inquiries regarding their juvenile record as though the case never occurred. However, with the increased use of private background check companies, we don't actually know what is already out there and who has records. So if an individual responds to inquiries regarding their juvenile record pursuant to Utah law, they may, and we do see this quite a bit, be denied employment or be terminated for lying. So this is just a quick example to show that not only is the actual process of expungement difficult to navigate, as I will explain in a moment, but even for attorneys, there is almost never an absolutely clear answer regarding expungements. So we'll start with, like Kaylee mentioned, the clinics are really set up to be a one-stop shop. So present at the clinics, we have everybody needed to really truly make it just a one-stop shop. So we have volunteer clerk, we have a volunteer prosecutor, we have a volunteer judge, we have multiple volunteer defense attorneys, we have a person who does fingerprints, and usually that person is Kaylee. And then there's one table for each step of the process. I do want to note that there are two types of expungements in Utah, and I want to clarify this to begin with so that it doesn't cause confusion as I'm explaining the expungement clinic. So there's an expungement for those who have been adjudicated of an offense, what I call a regular expungement. And then we also have an expungement for non-judicial adjustments, which are cases where there's no formal judicial action or adjudication. So these cases we call non-judicial expungements, or NJs. So depending on what type of expungement is required, the process varies slightly, and I will note that when applicable. So when a client arrives to the clinic, they fill out an intake form, which contains information needed to fill out the petition. If they don't already know what their juvenile case number is, because oftentimes we do get adults 20 years out from their juvenile records, they go to the clerk who helps them obtain their case number and who also opens the case file so that we're able to file documents that day. Then the client goes to a second table where they meet with a prosecutor who determines whether or not the individual is eligible based on the statute. At that step, the prosecutor can but isn't required to stipulate to the expungement. Because there may be victims, this decision whether or not to stipulate or to object can occur at an expungement hearing after the prosecutor has had an opportunity to speak with the client. So if the client is not eligible, they then discuss eligibility with a defense attorney who determines why they are not eligible, and then see if there's a motion that can be drafted to waive the eligibility requirement. If it's for a reason that can't be waived, or a requirement that can't be waived, then defense attorney will discuss what options that individual has. Once it's determined that the client is eligible for an expungement or a motion is drafted to waive one of the requirements, if the expungement is a regular expungement, then the client has to obtain their fingerprints for a background check. Like I mentioned, this is usually Kaylee, and she collects all of the fingerprint cards for all of the clients that attended the clinic. And after the clinic, obviously, she then submits it to the Utah Bureau of Criminal Investigation, and then the BCI office, after they run the fingerprints and run the background check, sends the background checks directly to my office a few weeks after the clinic, and then our office files it with the court. Usually an individual doing their own expungement would receive it and then have to figure out how to get it to the court. But with the clinics, our office takes care of that for the clinic clients. So after the fingerprints, the client meets with a defense attorney who helps them draft a motion to waive fees and then the corresponding affidavit. This motion is submitted along with any of the other motions to waive requirements. So they're submitted to the judge, who reviews them then and there and then makes a decision then and there. So if the motion is to waive fees is denied, then like Kaylee mentioned, the grant pays the filing fee. If the eligibility motions are denied, then the defense will discuss what needs to happen or needs to be done before the client is eligible. And in terms of eligibility, the two main ones that we see, you're required to be 18 years of age or older in order to get an expungement unless there's good cause. Additionally, 1 year after termination from a juvenile court custody needs to occur before you're eligible to apply for an expungement. So those are the two common requirements that we file waivers on. So then finally, the defense attorney helps draft the petition and we submit it to the court. Regular expungements require the background check and a hearing. Therefore, a hearing needs to be set at least 30 days out to allow the court to give notice to all of the agencies that have records. However, NJ expungement, non-judicial expungements, don't require a background check, or they also don't require a hearing. So the judge will either grant or deny the petition for a non-judicial expungement then and there. So either the client walks out with their record expunged if they had a non-judicial record, or they walk out with a date for their expungement hearing. So those are all the steps for the actual clinic. However, like I noted, the work doesn't stop there for at least the regular expungements. Prior to the expungement hearing, the attorney, the volunteer attorney, meets with the client to prep for the hearing and then also represents them at the hearing. Once the expungement is granted, for both regular and non-judicial expungements, it is the petitioner's responsibility to send the expungement orders to all of the agencies that have records that need to be expunged. This is also an example of how difficult an expungement can actually be. Even after all of our dedicated work at UJDA, working with the juvenile court and working with other agencies and our experience with expungements, we are still finding new agencies that need to be served because it's so hard in the digital age to know where information is going and who has information. So once we find every agency that needs to be served with an order, the agency is required to send back notice that they have actually, in fact, expunged the record. However, this usually doesn't happen without multiple requests and inquiries. I wanted to go over the clinic in detail to show how complicated and daunting an expungement can be for individuals doing them by themselves, and how helpful these types of clinics can be, where they just walk in, they know everything's going to be done for them within 2 hours. So I can only imagine how difficult it would be for somebody to try and do this all on their own. Drafting the petition, drafting motions, knowing that you could even draft a motion to waive certain requirements, seeing that they don't qualify because of the age or the time limit requirement, and say, never mind, I guess I just won't seek an expungement. So next, can you go to the next slide, Kaylee? Thank you. So my office and all the stakeholders involved in the clinics truly appreciate OJJDP for the funding to make this work possible. But as you can see, we are only reaching a tiny percentage of individuals and also youth who have records. So on average, Utah has about 17,000 referrals to the juvenile court each fiscal year. And of those, about 60% are non-judicial referrals. Again, those are the cases where there's been no formal adjudication, but records still exist, including petitions, arrest records, or just hold and release records. So even with the expungement clinics, we are still only seeing about 25 expungements granted each year. And that includes the expungement clinic and then those who are doing them on their own. As you can see, the COVID situation kind of put a dent. We were working hard to holding clinics throughout the whole state. And then COVID happened and we had to readjust the approach to just a call-in, but that call-in option is more time-consuming for the individual and also more resource-intensive because it's on a case or call-in basis. Therefore, we can't have multiple attorneys just there doing it all one day in 2 hours. So I think what this tells us, what these numbers tells us, is that, and also what my office is advocating for in Utah, is that there should be an auto-expunge process at the minimum for non-judicial records. But like Andrew mentioned, the expungement process should also be made as simple and clear as possible so people can get an expungement without us, without the clinic, without counsel. I think that the other issue we are facing, and another issue that Andrew mentioned, was that there is this misconception that juvenile records don't matter or that juvenile records are automatically expunged or sealed when an individual turns 18. It's not until it actually affects their career or their housing or their education that they realize their juvenile record exists and it's going to follow them through their entire life. So in an ideal world, I think two things would happen. Expungements would be automatic, at least at the very minimum for certain adjudications or certain records. And then two, I think juvenile defense attorneys would be expected to follow up with an expungement as part of the holistic representation. Expungement is rarely, if ever, considered part of the juvenile representation. I think expungement is such an important part in the youth's success, and it should be a requirement for representation. The logistics of making that happen are challenging. However, expungement really is the full circle of a youth court involvement. So it only makes sense that their case ends with an expungement and being represented for that expungement. But until that happens, we will continue to hold expungement clinics and continue to advocate for policy changes, and we will continue to help create accessibility to expungements for all youth, particularly youth of color who are disproportionately impacted in arrest, in the juvenile justice system, and then also in expungement. But thank you so much to OJJDP for allowing us to be a part of this important conversation, and we're excited to see what's next for expungement nationwide, but also in Utah.
Great. Thank you so much, everyone. I know it was a lot of information, a lot of great information, and I know the panelists have probably been seeing the questions coming in fast and furious. So now we'll go to the Q&A portion of our web event today. And so a couple of things before we sort of delve right in, because we've got tons of questions, and some of you all sort of answered some of these questions as you were speaking. As what we'll do is we'll do sort of a triaging of the questions that were submitted before the webinar, and then we will send those out to the presenters. We will answer those, and then we have folks' email addresses, so we will follow up with you and get the responses to your questions, because we know that a lot of you all are really engaged in this work and direct serving with young folks, and really want to sort of help them navigate this process as possible. So what we'll do is we'll start with some of the questions and comments that came in. And again, we'll try to get to as many of them as we can, sort of again with the caveat that we may not be able to because we have so many. So one of the comments that I sort of wanted to make before we get started, and just to dovetail on what Marina was saying about the disproportionality, and Andrew as well, of kids who come into contact with the juvenile justice system overall. And we had a comment from the field about how racial and ethnic minority kids are, of course, more likely to have greater contact with the juvenile justice system, and particularly, you know, in the front end of the system, because as we all know, doing this work, there's been a lot of work done, though not perfect, around kids in secure detention with the JDAI initiative and other initiatives and the national initiatives that have really focused on kids in secure detention facilities or confinement. And so we are really starting see the numbers go down there. And while juvenile arrests are down overall at a 30-year low, And this is a shameless plug for OJJDP's recent bulletin that we put out, recent lithograph that we put out on juvenile arrests. Even though arrests are lower than they have been, there's still great disproportionality there for racial and ethnic minority youth. So just wanted to make sure that, you know, we sort of preface that. And one of the, I think, frustrating things for me when I was writing this bulletin is there were no national data sets to sort of capture these data. And as many data sets as OJJDP has, of course, we have so many, we don't even capture these data. So this is something that we're discussing internally of how do we, you know, sort of capture the data, some of the data that Utah, that Marina and Kaylee just talked about, and how do we engage with other jurisdictions to see, you know, how many kids they're working with and sort of the demographic composition of those kids so we can start collecting these data. So, yeah, so just wanted to mention that before we jump in. So again, so many questions. So one question was, how does from Sarah, how does expungement and or sealing work in regards to sexually based offenses? So if a young person has these offenses, how does expungement work? So anyone can jump in, any one of the panelists.
Well, I'm happy to share based on, you know, how it's handled across the country, which is that many states all do it differently. Many of them do. Sexual offenses and serious violent offenses are often among the exceptions to either confidentiality laws, sealing laws, or expungement laws. You know, we set out in our core principles that all offenses should be covered by those laws for keeping juvenile records confidential, sealed, and eligible for expungement. You know, obviously, no state has hit a perfect score. I don't think on all of that, but we'd also say the burden should be on the prosecutors rather than juveniles to try to carry a burden to prove or show why their records should be entitled to expungement. If certain individuals or cases have a need for accessibility for certain agencies or individuals, or there's a public safety need or emergency need, the prosecutor should certainly make that showing and the court should make an appropriate ruling. But I think all offenses, and our position as an organization is that all offenses should be covered by the sealing, expungement, and confidentiality laws. I don't have Utah's law in front of me, but maybe you guys know.
So in Utah, the only two offenses that are not eligible for expungement is murder and aggravated murder. So sexual offenses are expungible in Utah. And I think the reason behind it is that what data and research shows is that youth who engage in problematic sexual behavior engage in those behaviors for different reasons than adults. So they engage in inappropriate sexual behaviors because of curiosity, because they are, well, a lot of it, surprisingly, there's normative sexual behavior among children, and that's kind of a weird topic and something that as a society we don't want to acknowledge for whatever reason. But sex play is very common among children. So having 8-year-olds be referred to court because of inappropriate touching a friend or a sibling through curiosity. What research says is that recidivism rate for youth who engage in these sexual behavior decreases and is significantly less than adults who engage in the same behavior. So having that record follow you throughout your whole life and you being labeled a sexual predator or whatever the case may be because of something you did in your youth, not necessarily because you wanted to hurt the other individual or were acting out in a threatening or predatory manner, is problematic for the same reasons that were discussed earlier. The stigma shouldn't follow a young person into their adult life. So for those reasons, because of the research, because we know that children engage in these types of behaviors for different reasons than adults, I think that Utah has acknowledged that those records can be expunged.
Yeah, and I just sort of wanted to follow up with Maria's comment because we did have a question asking, that whether if a juvenile is charged with murder or sexual offense, should they have their records expunged? And so I think you and Andrew did a really good job of sort of answering that question. And I sort of wanted to follow up with the sex offenses for kids. So a lot of you all may be familiar with sexting, which is now an offense in a lot of jurisdictions. So sometimes kids get charged with that, right? And even though that's, not what we would think in the classical sense of a sexual offense, it is classified as such in many states. So the sexting, of course, is kids sending text messages willfully back and forth, where they may have little to no clothing on. And so here in the DC metro area, we had a very huge case that caused controversy a few years ago of a young man who was, I think, 17, and who was sexting a 14-year-old. And it was, going back and forth, it was mutual. But her parents found out about it and pressed charges. And so by the time he sort of wound his way through the system, he had turned 18. And so then he had this sex offense on his record, and he was unable to access some educational state loans because of that offense. And so there really opened up a dialogue here of whether this young man should have this offense on his record to prevent him from going to college and getting funding to do so. So it's a really sort of complex question, I think, when you talk about, quote, what types of offenses. You have to really peel back layers, and I think as the lawyers would say, look at sort of aggravating and mitigating factors there that maybe contribute to that, which I don't know if states have gotten that sophisticated looking at mitigating and aggravating factors for kids who come through the juvenile justice system. But, maybe, some I know are better than others. So, yeah. So thanks to the panelists for responding to those questions. So let's just keep going here. So one question I think is sort of tangential or related to this question, so of expunging juvenile records and looking at juvenile court proceedings and keeping them public versus open. How do you balance the kid's right and family's right for privacy, but also make sure that the court is being held accountable for decisions that they make that may affect a child having a juvenile record sort of down the road? So yeah, turn it over to the panelists, and any of you all can jump in.
Well, from our perspective, we do believe that proceedings in the juvenile court, this isn't necessarily about family law or family court issues. It's specifically about the delinquency proceedings and the juvenile court's oversight of delinquency proceedings. We do think, in the same way we want to keep records in their juvenile and system involvement information and law enforcement information confidential, keeping public courtrooms for these proceedings non-public, absent a prosecutor or an interested party moving the court potentially for, with cause for why there's some great public interest, emergency interest, public safety that necessitates it. But the default should be that proceedings are non-public.
Awesome. All righty, we've got sort of a couple other questions, and this one you all may think is a little funny, and this actually comes from Pennsylvania. Why are there attorneys who do not explain this correctly, i.e. the difference between expungement, sealing, and confidentiality? Why can't some of these attorneys get this right, according to this gentleman, Joseph, in Pennsylvania?
As a non-attorney, I'll say it's because it's very complicated. I don't know why. I'm not an attorney, but I would say, from my perspective as the staff person on Utah's effort, kind of trying to explain this at large, I think the short answer is because it's really confusing. And something that Marina touched on, which was that there's sort of a myth, I guess you would call it, that if you have a juvenile record, you turn 18 and it's white. It's not available. You can't find it. You can't see it. It's gone. And so it's not even something that people think about often or consider often. And I would imagine that that extends to lawyers as well, who perhaps are more focused on the adult system or adult expungement and not as focused on the juvenile process and juvenile court and the potential consequences of a juvenile court record. But I'm not an attorney, so I don't know, but that's my point.
But you can play one on television like a lot of us do, Kaylee. That's fine.
To that, that's actually a really good point, because in Utah, an expungement doesn't mean what the definition says it means. An expungement in Utah is technically sealing the documents. However, our legislator, for whatever reason, has said expungement is sealing. So I think part of the confusion is that the two terms are used interchangeably. There's not clear direction based on the actual definition of which one is going to be used. So I think that may cause confusion and may contribute to it. But yes, I say expungement in Utah, but really it's sealing. There's still the record. It's just put in an envelope, and it can only be opened by court order. But for whatever reason, it's called the Expungement Act. We refer to them as expungements, but that's not the case.
Sure,
Yeah.
Andrew, did you have anything?
We saw across all the states, there's a lot of confusion. I am an attorney, and this is often confusing and took me a while to get up to speed on. Like Marina said, in Utah, and we saw in a lot of other states where the language of the statute is expungement, but when you read into the details and how they explain what you do when a record is expunged, what it really is a sealing. And in some ways, Utah's system, that's how sealing should work. It should be in an envelope and subject only to the court order. The way sealing works in typical civil and criminal cases, a lot of people just treat it as it's confidential. It's segregated out. There's a list of who can access it and by notice or otherwise, list of exceptions. And so it really varies. And there's also other words like expunction sometimes used. Sometimes, sealing is used, but right, it's not as segregated or as closed off as just limited to a court order. So it varies every state. And if it takes, Andrea, Marina, who works on this, Kaylee, and myself have to work on this, in a lot of depth to start to understand, and that's just for one specific state. So making laws that are very clear and follow the way we're defining it here would be helpful.
Sure, and I think one of the ideas
maybe some guidelines from OJJDP too, like the bulletin. We need more of this, and hopefully states start following along.
Yes, it's like you read my mind. I think we're starting to meet and talk about this so much. It's like we're having osmosis, a meeting of the minds here. One of the things that we're talking about at OJJDP is how we can sort of expand our efforts around this issue. And we actually talked this morning. I talked with OJJDP leadership about this. And so one of the things that we're thinking of almost immediately is maybe having a series of webinars just on this topic, but focusing, really getting down into the nitty-gritty about some of these questions that people are asking. So sorry for you guys, we've created a monster here, and really focusing. And so that's sort of one issue that we're really discussing, and potentially some training and technical assistance through our National Training and Technical Assistance Center. And of course, we're exploring funding options. So those conversations are now going on. And so, yeah, I wanted to just sort of follow up really quickly before we wrapped up, is that we had another question about resources. And we had several questions about resources, like where do I go to get some of these resources? In the bulletin, I discussed the Clean Slate website, and that's jointly funded with OJJDP and another one of our sister offices, the Bureau of Justice Assistance, or BJA, and that's in the bulletin. And on that website, it sort of breaks down by state, sort of what young people have to do, for adults and juveniles, actually, the process that they can go through in their state. There's a big, huge map when you open up, and you can click on your state, and you can see sort of the steps like they do in Utah, of laying out what young people would have to do to expunge their records. And so there are so many barriers. You got to pay for it. You got to know where to go. You got to fill this out. And it's, you know, that's just sort of, it's not conducive to an adult to do it, let alone a young person. So with that, I think we'll wrap up. We're a couple of minutes over, but really sort of appreciate the feedback, the questions, the comments. They're still coming in. And I'm sure my panelists, colleagues here will kill me when I say keep them coming. And we will get to all of these questions and answer them and get them back to you. And if OJJDP does decide to move forward with sort of doing a series, you'll be the first to know. We'll send this out via all of our multimedia platforms. So we want to thank everyone for attending today and with your questions and comments and engagement, and know that OJJDP is going to work hard to support the efforts of our co-presenters here and of your efforts out in the field. So with that, William, I will turn it over to you.
Yes, thank you very much, Andrea, and thank you to all our presenters for wonderful content. I know we're a couple of minutes over, but before people leave, I just want to, again, say thank you to our presenters and to OJJDP for such a wonderful webinar and fantastic content to cover. Individuals in the chat here are definitely singing you all's praises, so great job today, and congratulations on a great web event. Before we leave, really quickly, just a couple of reminders to folks. Please remember that following today's event, you will receive an automated email from WebEx with a certificate of attendance. Please make sure you add messenger@webex.com to your safe sender list to ensure that you've received your certificate. If you would like to connect with OJJDP, please note that OJJDP is available on multiple platforms here, as you can see. Really quickly before I move on as well, my co-host has placed a link inside of the chat for folks to access the PDF of today's web event, where you can go in and click these links. However, I'm going to go ahead and share with everyone again the PDF in the transfer file there. So you'll see it pop up on your screen. It'll say file transfer. Just simply click the name of the document and download, and that should give you access to the PDF there for today's web event. So again, connect with OJJDP through these multiple locations here. You can connect with NTTAC through this URL, or you can also connect to us by signing up through our listserv to get more information on upcoming events, or even check us out on Facebook at OJJDP NTTA. If you'd like to get in contact with the OJJDP Help Desk, the information for that is here on this slide, as well as OJJDP's website. I encourage folks to please go to the website and check out the information there in order to get more information as you so please. Also be sure to sign up for OJJDP's JuveJust listserv, where you can get more information about upcoming events, and then view the upcoming events page on OJJDP's website at the URL here. Do you have a training or technical assistance need? Well, if so, we encourage you to please go to the TTA 360 URL here, where you can easily go in and get access to the platform where you can submit your TTA request there. Please note again, as I mentioned earlier in the beginning, that OJJDP's multimedia page does include past webinars with OJJDP, but if you would like to get any supporting materials for any of those web events, contact the TTA Help Desk that's located at the email address here on this slide. And finally, a couple of quick plugs for some upcoming webinars that we have. We have our prosecuting carjacking cases in juvenile court webinar. That is only for prosecutors. So please note that's coming up on June 9th. And in June, we have a series of solicitation webinars. So anyone who's part of an agency looking to get OJJDP funding for various OJJDP areas, please note that we have a couple of solicitation webinars coming up, one on June 10th for Juvenile Justice System Reform Initiative, We have a solicitation on family-based alternative sentencing coming up on the 11th, and then Title II solicitation is coming up. We are dividing that webinar into two parts. One is the programmatic piece, and then the second is the compliance piece. So please note the dates for those two webinars. And then finally, the last thing before you all hop off, another final poll question, and we basically want to know, how do you plan to apply the information that you've learned from this webinar? And so I'm going to go ahead and open that poll for everyone and leave it up for just a little bit. Again, we just want to know, how do you plan to apply the information you've learned from this web event? So simply just go there and you can click on multiple options there. It's not one single choice. You can click on multiple choices here to let us know, how do you plan to apply the information that you've learned here. I'll leave this up for just a couple of more seconds for folks as you all file out of the virtual room. But again, thank you to everyone who's joined here today. Take care and have a wonderful afternoon. Bye-bye, everyone.
Hey, thanks, everyone.